Hello, everyone, and happy Election Day. Welcome to Uncivil Law, and for today's story, we're going to cover a case. You may not have really heard about it. It was kind of a small deal, but, it does touch an election issue, and because it is Election Day, I thought maybe we should go back to this historical case, which I'm sure will have absolutely no relevance of any kind to anything that is happening today. This is the case of Bush versus Gore from Florida, now decided by the U.S. Supreme Court. In this case, Gore lost the election in Florida, and there were many, many lawsuits over it. And the U.S. Supreme Court was tasked with figuring out whether or not what the state was doing, trying to count ballots and such and so forth, was proper, and whether or not they violated the law. So we're going to read this as a pure historical relic that has absolutely no relevance to today. Let's get started with this. As part of the 2000 election campaign, Vice President Gore sought a manual recount in Volusia, Palm Beach, Broward, and Miami-Dade counties pursuant to Florida election protest provisions. So Vice President Gore seeks a recount in 4 of the many counties of Florida, and that may be ultimately what will doom him in the end, as we're going to see how this develops. The Florida Supreme Court, however, set a deadline of November the 26th. So they said, here's what you have to do. It was many different lawsuits. The Florida Supreme Court said, you have to get this done by November 26th. Okay. So then on November 26th, the Florida Elections Canvassing Commission certified the results of the election and declared Governor Bush the winner of Florida's 25 electoral votes. On the 27th, Vice President Gore, pursuant to Florida contest provisions, filed a complaint in Leon County Circuit Court contesting the certification. So there was a count, there were some lawsuits, there was an extension of time by the Florida Supreme Court. They did a recount, and they said, okay, by our recount, we think that Bush has won the election. And so the next day after this, he files a suit, and he'd like to contest the findings of the commission. All right. The circuit court, which here is a trial level court, because some states call the trial level courts circuit courts. There are usually a couple different kinds of trial courts, and circuit courts are usually the broader kind of trial court. So here, the trial court denied relief, stating the vice president had failed to meet his burden of proof. He then appealed to the First District Court of Appeals, the Court of Appeals, which then certified the matter to the Florida Supreme Court, which I find just particularly hilarious, because I've never actually seen that done in any other case. Not to say that it can't happen in Florida or any other state, but I've never seen that happen. Normally when you have a certification question, this is what happens if one jurisdiction needs to ask another jurisdiction about their law. And you usually see this in federal cases, but it does pop up occasionally in state cases, particularly if they're having to interpret another state's contract law provisions or something like that. So it does happen occasionally, mostly in federal court. But what you can do, one of the things you can do is you can create a certified question. And so you can ask the highest court of the state, hey, what is your state law on this issue, if it's a little unclear? So that's normally what it is, like the federal government asking the state, what is your law? Or another state sometimes asking a state, what is your law? But here, this is unusual because it's the Court of Appeals of the same state asking its boss, the Supreme Court, what is the law? Which is hilarious. The Court of Appeals didn't want any one piece of this. It's like, please just take this directly off my docket. Okay, so apparently it's a thing we can do in Florida. All right. Just a little interesting touch there. So accepting jurisdiction, because, the Florida Supreme Court affirmed in part and reversed in part. Now they're dealing with the trial court's decision. The court held that the circuit court, again, trial court in this context, had been correct to reject Vice President Gore's challenge to the results certified in Nassau County and his challenge to the results in Palm Beach County, its determination that 3,300 ballots cast in that county were not, in the statutory phrase, legal votes. So he's challenging the results in Nassau and challenging a determination that 3,300 ballots were not valid ballots. So 2 contentions he's making, okay? The Supreme Court of the great state of Florida held that Vice President Gore had satisfied his burden under the respective law with respect to his challenge, failure to tabulate, by manual count, 9,000 ballots on which the machines had failed to detect a vote for president. The court therefore ordered a hand recount of the 9,000 votes in Miami-Dade County, the ones the machine had not counted. Observing that the contested provisions vest broad discretion in the trial judge, to provide any relief appropriate to the circumstances. So, the law allows the trial court to provide any relief that is deemed necessary or prudent, and the trial court said, well, let's do these kinds of particular recounts. And then the Florida Supreme Court said, essentially, agreed in part and disagreed in part. As to part, they said, no, you're wrong. But as to other parts, they said, yeah, you're right. And you can order this recount. It's within your broad discretion to do. So that was the decision of the Florida Supreme Court, which brings us to the United States Supreme Court. Can the Florida Supreme Court do that? Let's read on. This petition before our court, the Supreme Court thus presents the following questions. Whether the Florida Supreme Court established new standards for resolving presidential election contests, thereby violating the United States Constitution, and failure to comply with another provision of the United States statutory law, and whether the use of standardless manual recounts violates equal protection and due process. With respect to equal protection, we find a violation of the Equal Protection Clause. So, the Equal Protection Clause, as I'm sure you well know, basically in so many words says you have to treat similarly situated people similarly. You have to treat people who are on even par evenly. And that seems to be a lot of the problem. And a lot of this problem was induced by Gore. Because what Gore did was ask for a recount in only 4 counties. And that's a bit of a problem. Because they're trying to tailor the remedy to the lawsuit that he brought for the 4 counties. But now you have a problem, because suddenly now you have the Florida Supreme Court saying, okay, we're going to order these specific remedies in these specific counties. And state law does allow you to issue broad remedies, to be sure, but you still have an equal protection problem. Because now some people's ballots are going to be counted differently, under different conditions, and with potentially different rules than other people in the same stage, even though they're similarly situated. So then it becomes a question of like, okay, is this an equal protection violation because you're doing that? The U.S. Supreme Court says yes. Let's read on to discuss more of why. The individual citizen has no federal constitutional right to vote for the electors for President of the United States. Or to put it another way, they have no constitutional right to vote for the President of the United States. This may come as a bit of a surprise to some of you that you don't have a constitutional right to vote for the president, but you don't, because of the way the Constitution is structured. Because the Constitution says very clearly, the states shall choose their electors by any method they choose. If they choose voting, there's a whole bunch of bases they can't discriminate on. The Constitution says they can't discriminate on the basis of sex, the basis of race, the basis of someone being under the age of 18. But if they don't want to grant the right to vote to anyone, that is in fact an option that they can do. You have no right to vote for president, unless the state legislature chooses a statewide election as the means to implement this power. But, they don't have to. It's an option, but they don't have to. And then they point out from a 1892 case, the state's legislative power to select the manner for approving electors is plenary, which is another way of saying absolute. It is an unchecked power. It is unchecked. The state legislature can select the manner of how these people will be done in any manner whatsoever. It is plenary. It is absolute. It may, if it so chooses, select the electors itself. Yes, that is in fact an option you may not have been aware of. Yeah, the state can choose its method, including, hey, what if we didn't have elections? What if, instead of having elections, we, the state legislature, just decided that, the Republicans get our electoral votes, or the Democrats get electoral votes? Is that a legal option? Yes, it is. Yes, it is. Now, they have to decide that in advance. They can't decide it on the fly, but once they choose a method, they have to stick with it. But they can actually change their mind. Whatever. And so that's an option. They can just say, how about the Republicans win? And everyone will be like, wait, what? Yeah, that's definitely a thing they can do. Yep. Constitution's clear. History has now favored the voter. We now think maybe voting is a good thing. Okay. So each of the several states, the citizens themselves vote for a presidential elector. That's also an option. When the state legislature vests the right to vote for president in its people, the right to vote as the legislature has prescribed is fundamental. So if you do this, then it is a fundamental right. And one source of fundamental rights lies in its equal weight according to each vote and the equal dignity of each voter. Equal protection under law, right? So if you do this and it's a fundamental right, then equal protection kicks in. The state, of course, after granting the franchise, can take back the power to appoint the elector. So yeah, they can change their mind and say, how about we just do it? That is an option. And then they say, quoting this here, there's no doubt of the right of the legislature to resume the power at any time, for it can be neither taken away nor abdicated. So that means, hypothetically speaking, it would be absolutely legal. And I know you guys are going to love this because the power can't be abdicated or taken away. You guys are going to really love this. That the state legislature could have an election and they could count out the votes. And the state legislature could say, you know what? Our citizens have voted improperly. They have overwhelmingly voted for the Democrat for president. But you know what we think? How about the Republican? How about the Republican wins and we're going to pass a law on that they win? And that's the thing they can do because they can't abdicate. It's their power. It's plenary. It's absolute. They can take it away at any time. Outstanding. So that's an option, yeah. Equal protection applies as well as to the manner of the exercise, how the voting is done. If you're going to do the right to vote is, if you do it, equal protection. And also to the manner of how it's done, equal protection. Having once granted the right to vote on equal terms, the state may not, by latter arbitrary and disparate precedent, value one person's vote over that of another. They have the right to not value anyone's vote. That's an option. But if they're going to value one person's vote, they actually have to weigh everyone's vote equally. So that's a bit of a bummer if you're the legislature. It's like we can value no one, but if we value one, we have to evaluate them all. Yeah, well, what are you going to do? The question before us, however, is whether the recount procedures in the Florida Supreme Court has adopted are consistent with this obligation to avoid arbitrary and disparate treatment of the members of the elections. So that is the thing that is really going to go here. So that is the operative question. So the Florida Supreme Court, when they are casting their remedies, are they doing it in a way that protects everyone who's similarly situated equally? Now, it should bear note here that to say things are being done equally doesn't mean that literally the same thing has to be done to every single person, but it has to be at least equal in its operation. So you could have different standards or different things in different places, but they all have to they all have to be similarly situated. So you have to treat similarly situated people the same. That doesn't mean identically. It's a little bit nuanced there, and hopefully I'm making that point clear. So to be equal protection doesn't have to be identical, but it has to, for similar situated, it has to be a similar kind of treatment. So hopefully that's a little bit clearer. And so the question becomes, did the Florida Supreme Court do that or not? The Florida Supreme Court has ordered that the intent of the voter be discerned from the ballots. From these ballots that were challenged, specifically, these specific ballots, because remember, they weren't referring to all the ballots. There was the 9,000 number and there's a 3,300 number. So when they say such ballots, they don't mean all ballots, they mean those ballots in particular. Okay, for the purposes of resolving this equal protection challenge, it is not necessary to decide whether the Florida Supreme Court has the authority under the legislative scheme for resolving election disputes to define what a legal vote is and to mandate a manual recount implementing that decision. So there is this clause here. So they say we're not going to decide this issue because, of course, the Supreme Court is not going to decide more than they are. But it may be possible that the Florida Supreme Court can change the methodology statewide. Maybe. That's an operation of state law, maybe federal law, but we'll deal with that another time. So maybe the Florida Supreme Court can adopt a standard that's uniform. And maybe it can do this after the fact. And maybe it can put forward an order that will manifest that. So maybe that's an option, but that's not what they did, so we don't have to answer that question today, and we're definitely not going to. So that remains a question for another day. The recount mechanisms implemented in response to this decision do not satisfy the minimum requirement for non-arbitrary treatment of voters necessary to secure the fundamental right. So here, that was arbitrary and capricious. Florida's basic command for the count of legally cast votes is to consider the intent of the voter, which is a perfectly reasonable thing to do. We want to figure out what did the voter want to have happen. That's fine. And then the Supreme Court also says that's fine. This is unobjectionable as an abstract proposition and a starting principle. Yeah, figure out what the voter wanted. Great. The problem, however, inheres in the absence of a specific standard to actually do that. Yeah, that's the problem. This is where this thing actually went down. You don't have a specific standard of how you actually do that. You're leaving it up to the whims of whoever's trying to figure out what that is, and that's a no-go. The problem ensures the formulation of the uniform rules to determine intent based on recurring circumstances is practical, and we conclude necessary. So, yeah. So if you're going to say that the issue is the intent of the voter, fine, you can do that. And then you just have to have rules. How do you determine that? What are the rules for it? And then promulgate those rules. And then you didn't really do that, though. That's the problem. You just said, hey, county boards of elections, go figure out the intent of the voter without really telling them what that meant. That's kind of a problem. Yeah, no, that's not going to fly. The law does not refrain from searching for the intent of an actor in a multitude of circumstances. Yeah, trying to figure out what a person's intent is pretty common in law. We do it a lot, like all the time, pretty much in all the criminal cases, to be quite honest. What was the person intending? Because that's quite a frequent question. So yeah, we are often trying to divine the intent of a person. But this is a different situation. Why is it different? Because the question is not to whether or not to believe a witness, which I don't even know how you begin to divine concrete rules for that. We haven't even figured that one out yet. So we just kind of leave it up to the jury to figure out, if they're credible or not. But that's not what we're doing. We're not trying to figure out a person based on like their testimony live. We're trying to figure out how to interpret marks or holes or scratches on an inanimate object. That's different. So the search for that intent can be confined to specific rules to ensure uniform treatment. So yeah. So for all the weaknesses that trying to figure out what a person's intent is, if we're in criminal law land and we're trying to convict this guy of this thing, one of the things we might want to know is what was his intent, because pretty often that's an element of the statute. You have to have the intent to do something or some language close to that. So we have to figure out, well, we know he did the thing, right? We know that might be a thing for the jury, right? We know he did the thing, otherwise known as actus reus, but what is his mens rea? Did he have the requisite mental state, such as intent? And let's go figure that out for a while. So in criminal law land, we don't really know how to do this objectively. We don't really know. We got nothing. Because human experiences are too variable. So we kind of just tell the jury to figure it out as best they can and use your common sense and the things you know and don't know about whether to trust people and go forth and hope for the best, because we don't know how to do that. But here, well, we're not dealing with people. We're dealing with punch cards or other sorts of mechanical things. So we can have a discrete rule. If the checkbox is here, then do this. If there's more than one checkbox, do this. If there's no checkbox, but there's an indentation, do this, and so forth and so on. So we can have concrete rules about how to deal with this. And maybe, that is a thing we could do. Like, more of a scientific inquiry kind of thing. Yeah. The want of those rules, because we don't have them, because not so much from the Florida Supreme Court, has led to unequal evaluation of the ballots in various respects. Yeah, so the ballots are not being evaluated evenly because human beings trying to interpret, just figure out what the intent is, are doing different things, and that's a problem. As seems to have been acknowledged at oral argument, the standard for accepting or rejecting a contested ballot might not only vary from county to county, but even within a single county from one recount team to another. Because, yeah, we have lots of different people counting these ballots manually. So it's not even a problem of different counties having different rules, but it's even like within the same county, within the same voting districts. We have a whole bunch of people and we told them, go figure out what the intent of the voter is. And different people might come to different interpretations based on the unclear standards. And we're not talking about, is this witness credible? Which, how do you figure that out objectively? Good luck. But we're talking about, does the ballot say this? And it's a physical thing. So we could have concrete rules and not so much. And because we don't, we got unequal treatment. And yeah, that's going to be a problem. For example, a monitor in the Miami-Dade County Counting Office testified at trial that he observed 3 members of a county canvassing board applying different standards in defining a legal vote. That's a problem. And testimony trial also revealed that at least one county, and this is just super fun world, one county changed its evaluation standards during the counting process. Well, that's just all the super fun, isn't it? Yeah. One county is, so we have one county that can't figure out how to do it and lots of different people. And then we even have one county that's redefining their standards on the fly. That doesn't really feel like equal protection to everybody. Yeah, that could be an issue. An early case in our one-person, one-vote jurisprudence arose when the state accorded arbitrary and different treatment to voters in different counties. In that situation, the court found a constitutional violation. We rely on these principles in the context of the presidential selection process, wherein invalidated a county-based procedure that diluted the influence of citizens in larger counties in the nominating process. The state Supreme Court ratified this uneven treatment. It mandated that the recount totals from 2 counties, Miami-Dade and Palm Beach, be included in the certified total. The court also appeared to hold sub silentio, that is, without saying it. So they appeared to hold this without saying this. So they didn't say it, but this appears to be what they said. Anyway, the recount totals from Broward County, which were not completed after November 14th certification by the Secretary, were to be considered part of the new certified vote totals, even though the county certification was not contested by Vice President Gore. So yeah, even though that county was not part of the lawsuit, the Supreme Court ordered a remedy for a county he didn't challenge. Why not all the counties he didn't challenge then? Why not statewide? Each of the counties used varying standards to determine what was a legal vote. Broward County used a more forgiving standard than Palm Beach County and uncovered almost 3 times as many new votes, a result markedly disproportionate to the difference in population between the two counties. So yeah, we can see this in the manifestation of it. It's like, you didn't have even treatment, and different counties are doing different things, and one county has 3 times as many, and it's not because they have 3 times as many people. So different people or different counties are getting different weights of their votes. So, that's not ideal. In addition to these difficulties, the actual process by which the votes were to be counted under the Florida Supreme Court decision raised further concern. So the procedure was not well specified. And if that wasn't enough problem, let's talk about some of the things that actually happened in reality that gives us additional pause. That order from the Florida Supreme Court did not specify who would recount the ballots. The county canvassing board were forced to pull together ad hoc teams of judges from various circuits. This would be trial court level stuff. So we got trial court judges, but they had no previous training in the handling and interpretation of ballots. So, pulling sitting judges to help you with this is not the most unreasonable approach possible, but they're dealing with novel circumstances here. They're dealing with the standard that has been unspecified by the Florida Supreme Court, and all these judges acting independently are basically coming to different interpretations. And also, they don't have any experience in counting ballots, so they don't know what they're looking at or what they should be looking at, which is probably part of the reason that they're redefining standards on the fly. And this isn't just a trial court case where you can just upset things in the middle of the operation. No, you got lots of different people here. You got to kind of, treat everyone the same. Meh. Furthermore, while others were permitted to observe, they were prohibiting from objecting. So other people were allowed to observe, but they weren't allowed to say, hey, maybe this isn't going so well. The recount process in its features described is inconsistent with minimum procedures necessary to protect the fundamental right of each voter in the special instance of a statewide recount under the authority of a single state judicial officer. And then they say our consideration is limited to the present circumstances. For the problem of equal protection, election processes generally presents many complexities. Okay, so let's try to unpack this paragraph. So we'll keep it on screen as we're talking about it so you can read about it while we're talking about it. So what they say here, they say 2 things that are kind of important. So they say the features described here with respect to equal protection are inconsistent in this particular circumstance, this special instance. And this is special because of a special reason. There is a statewide recount under the authority of a single state judicial officer, namely the state Supreme Court. So in the normal election land, for whatever its problems may be, normal election land, I don't know how Florida does things normally, not that particularly matters, but, maybe every county devises its own rules, and maybe every election board devises its own rules or whatever. And so, but that's okay, because maybe it's okay. We haven't gone that far, but maybe it's okay because in that situation, the state, by its operation of law, has split this into whatever system they've split it into. So they've got, I don't know how many counties there are in Florida, 80. I don't know. They got 80 different people that are promulgating their own rules. So maybe that's an equal protection problem, maybe not. But at least that situation, we've got a whole bunch of different people casting rules. So that's one situation. But in our situation, we're not there because we have a statewide recount that's being directed by one person, namely the state Supreme Court, under one authority. So we don't have whatever that problem is in normal election world. So the state Supreme Court could promulgate rules statewide because, they're the state Supreme Court. That's the thing that they're capable of, and making sure every ballot is done properly. And so then they say our consideration is limited to these present circumstances. For the problem of equal protection in election poses many complexities. And there they have a very fair point because, as you might appreciate, in our election system that we have in the United States. And they're thinking ahead. They're thinking not just to Florida, they're thinking to all the states, right? They're thinking to all the states and all the many myriad of ways that they do elections. Maybe some states have a singular election board. Maybe some states do it on the county level. Maybe some states do it on a precinct level. Maybe some states have this technology in one place and that technology in another place, or whatever. So it's like there are a lot of different potential combinations of this that might exist out there in the ether. And so, we can't really speak to all those many possibilities. That is way beyond our ability here. So what we can do is say, whatever those situations might be is a problem for another day. But what we have here is a singular state authority that is speaking uniformly with the voice of God from on high. So in this situation, our consideration is limited to this somewhat unique circumstance because this isn't how normally it's done. But, because normally it's really, really complex. But in this situation, it's a little less complex because for all the complexities it has, which is many, it has one fewer complexities. Namely, this is one single authority that speaks from on high. And so, we're not trying to speak to all the things. We're just trying to speak to this one thing. And, we're not really trying to say what to do in other elections. Please don't ask. The questions before this court is not whether local entities, in their exercise of their expertise, may develop different systems for implementing elections. Yeah, that's definitely not the question we're facing right now. Hopefully no one will ever ask us. Instead, we're presented with a situation where a state court with power to assure uniformity, because, state Supreme Court, has ordered a state recount with minimal procedural safeguards. Didn't really tell you how to do this. When a court orders a statewide remedy, or, not so much because it was only limited to particular counties, there must be at least some assurance that the rudimentary requirements of equal protection and fundamental fairness are satisfied. And you're like, yeah, no, we're not trying to figure out what happens in normal election world where different counties and different election boards or different whatever are promulgating rules with different election machines and blah, blah, blah. We are definitely not trying to figure that out. But, when we have a single authority, the state Supreme Court, that has the authority to issue a ruling for the entire state, because, state Supreme Court, then thankfully we have one fewer complexities than we did. And so they could issue a uniform thing and then not so much, and that's a problem. Upon due consideration of the difficulties identified to this point, it is obvious that the recount cannot be conducted in compliance with the requirements of equal protection and due process without substantial additional work. This would require us to reformulate the rules. It would require not only the adoption, after an opportunity for argument, of an adequate statewide standard for determining what is a legal vote and practicality procedures to implement them, but also an orderly judicial review of any disputed matter that would arrive. So this would, require us to do a lot here. The state Supreme Court of Florida has said the legislature intended the state electors to participate fully in the federal election process. That's probably true. They probably would like their electoral votes to be counted, yes. The statute, in turn, requires any controversy or contest that is designed to lead to a conclusive slate to be completed by December the 12th. So the law says you must complete any challenges by December 12th. That's an operation of state law. That date is upon us. Yeah. And there is no recount procedure, because I think it was 3 days after this decision was decided. Yeah. Or something like that. That date is upon us, and there's no recount procedure in place under the state Supreme Court order that comports with minimal standards. Yeah. Because it's evident that any recount seeking to meet the deadline would be unconstitutional, because how in the heck are you going to do this in 3 days? No. We reverse the judgment ordering a recount to proceed. So they killed the recount because the state Supreme Court kind of screwed up by not issuing standards. And also, it wasn't wholly their fault because the Gore campaign also screwed up by bringing this enforced for specific counties, because then you have this whole disparate treatment problem. Now, the reason he picked those 4 particular counties, you shouldn't have to figure out. He thought that those would be the best places for him because they would have the most Democratic votes. So he picked them very strategically. So the reason he did it makes sense. But when he did that, he's now treating 4 counties differently than all the rest of the counties. And now suddenly you have a state Supreme Court speaking. So Gore kind of screwed this up by only asking for recounts from 4 counties instead of statewide. And Florida State Supreme Court screwed this up by not issuing something that resembles some kind of objective material on what they could be. I mean, there might still be some issues in trying to interpret somewhere, but you didn't even try. All you just said is go interpret the intent without any guidance. That's not going to fly. And there's not enough time, because it's 3 days from now. There's no way we're going to be able to put together an order in that time trying to figure out everything. It's just no. 7 justices of the court agree that there are constitutional problems with the recount order that demand a remedy. So This is often thought of as a 5-4 decision, but in some ways it's not, because seven justices said, yes, there is a constitutional problem here. So 7 justices said they screwed up. So, yeah, it wasn't just the 5 conservatives. 7 people said they screwed up. So then the only disagreement was as to what should we do about it? What's the remedy? Because the Florida Supreme Court has said the Florida legislature intended to obtain safe harbor benefits of 3 U.S.C. 5, which deals with when electors are counted and so forth, Justice Breyer proposed a remedy, namely remanding to the Florida Supreme Court for its ordering of a constitutionally proper contest until December the 18th. So they said, well, Justice Breyer says, well, what if we give them to December the 18th? And said, well, we can't do that because there's the safe harbor provision that requires things to be done in a certain time, and it would go past that time. It would be, and Florida has said the legislature wants their votes to be counted, and if they don't have the safe harbor provision, their votes might not be counted. So that we can't do that. We don't have the time. So therefore, that would contemplate action that would violate the Florida election code and hence could not be part of an appropriate order. So Justice Breyer's proposal is like, well, if we give them the 18th, it's like, well, no, we can't do that because then they lose their federal safe harbor and they might not have their electoral votes counted. And the Florida Supreme Court seemed very adamant, and the Florida legislature seems very adamant that they would like their electoral votes counted, which, you didn't need me to tell you that to know it's true. So it's because they are adamant they want their votes counted, because of course they do. We can't extend it to the 18th because they might lose the safe harbor protection and there's just not enough time. So we can't do anything here. Thus, that brings us to the end of the case of Bush versus Gore. A controversial decision to be sure, but 7 justices agreed that there was a constitutional violation. And there was a disagreement as to the remedy. And that's the remedy. The majority said that under the operative state law and under the operative federal law, votes had to be counted by a certain date in order to be afforded a safe harbor provision that's provided by federal law. And there was just no way that they could do it because the date was already upon us. This was decided like same day. This was decided the 12th. This was the same day. So there was no time to be able to do that within the operation. So, Breyer's suggestion of let's give them an additional 6 days, maybe that could be done, but it would violate the safe harbor, violate state law, so we can't afford that remedy. So I know that, I think this case gets a bit of a bad rap. I think it gets a bit of a bad rap. There's definitely reasons to disagree with it, but I think this case came out in large part because of the way Gore set it up. By only going after 4 counties, he created a problem for himself. He had a strategic reason to do so, but it ultimately led to a legal problem. And I'm not saying that he could have saw that coming in advance. I'm not sure anyone could have seen that coming in advance. But that was the correct legal decision. At least 7 people at the Supreme Court thought it was a violation. So hopefully there will be no reason for us to ever refer to this case ever again, and that will be the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.